gentlemen, a quick question that did drop in from our audience, just asking for a bit of best practice here. And it's just asking a hypothetical scenario. What if one's company were to discover an issue but decided not to voluntarily disclose? What would be the best way, in your opinion, to protect oneself?
I guess maybe I'll start, Matt, and then welcome your input as well. I think it goes back to we talked about several shadows that you operate under. And I think certainly if you discover something and there's not a legal or contractual obligation to disclose it, the risk is obviously that years from now, and maybe even if you are no longer at the company, your predecessor is asked about it by an external regulator, an external auditor. You need to have in mind, okay, if I'm not around and this issue resurfaces, what record do I want to leave behind? And ideally, it would be a record of a fair assessment of the allegation, a work plan, if it was appropriate, assuming that it's not some basic HR complaint where people just aren't getting along, but if it's a serious allegation, particularly anti-corruption or anti-money laundering related, what was the work plan? What was done? What was the independence of the people who did it? To whom did they report, for example? Hopefully there's a factual record created of the outcome. And I think most importantly, including under recent guidance from the U.S. Department of Justice, but also from other regulators, did you identify root causes? And maybe there weren't any, maybe it was truly a bad actor, but were there root causes? And if so, did you document how you designed and implemented remedial actions to cure those root causes?
I would say that's the textbook answer for how to get away with not self-reporting to a regulator. You remediate the problem properly, and hopefully in the future the regulator takes the view that the matter was adequately dealt with at the time. But I'm going to posit a slightly different position, which is that it really depends on the size of the problem and the size of the firm. If you're dealing with a multinational, and if you're dealing with a serious corruption or fraud problem, you've got a lot of stakeholders who have an interest in knowing the truth. Certainly with fraud, you've got your investors, your stakeholders, and possibly certain in the regulated sector, you may have some obligations. But Mike is definitely right that you look to see whether there are any mandatory obligations. But typically, if you have a multi-jurisdictional corruption problem, you're going to find that things tend to slip to the lowest common denominator, and it becomes very difficult to not disclose in those circumstances. So that's why I say it really depends on the size of the problem and the size of the firm. There are so many triggers that could cause a regulator to find out that problem occurs, and then you face the problem, as many companies have done, of being behind the ball and be called in by the regulator to say what's his conduct. I think the other thing just to note, because this is a very difficult question and we could talk about it for an hour alone, is at the very beginning of an investigation you don't, and quite often can't tell the scope of it. Is it just a problem with a particular person or a particular business unit or a particular region, or is it systemic? And that might take you some time to work out, and you've got to do the work to find out how bad is it before you take the decision to report or not. Yeah, I would say that Mike's answer, is absolutely textbook, where you find something reasonably small within a large company. But if that problem was throughout the company, I think it becomes far more difficult to sustain a position of non-disclosure.